Hi, my name is Josh Blackman. I am the president of the Harlan Institute, and it's my honor to welcome you to the 2022 Harlan Institute Ashbrook Virtual Supreme Court competition. Today, we're mooting the case of Students for Fair Admission versus University of North Carolina. Today, we have two teams. First, petitioners from Greenwich High School in Connecticut, Connor Hone and Aubrey Niederhofer. And second, from Creekview School in Creekview, Texas, we have Kayla Ricker and Caroline Reddy. Okay, petitions, when you're ready, please begin.
Mr. Chief Justice, and may it please the court. I am Aubrey Niederhofer representing the petitioners alongside my partner, Connor Hone. Would the court benefit from a brief statement of facts of the case?
Please.
The University of North Carolina employs a holistic admissions process which considers race as a demographic factor. In an attempt to comply with the precedents of this court, it gives no automatic plus or minus to any member of a specific racial group. However, the clear effect of this policy is to give a preference to groups UNC defines as underrepresented minorities. For example, evidence from statistical analysis of UNC's admissions program shows that an in-state male Asian American applicant to UNC whose statistical chance of admission would be 25% based on grades and other metrics would have a 63% chance of admission if treated as Hispanic and an 88% chance of admission if treated as Black. We'll now move into our written material. Racial classifications have always been held by this court to be presumptively invidious under the Equal Protection Clause of the 14th Amendment. Thus, UNC must prove that its admissions policy, which makes a racial distinction, satisfies strict scrutiny. In light of modern developments, it is clear that no university admissions policy that considers race may satisfy strict scrutiny.
There are ultimately two arguments for why a race-conscious admissions policy could pass strict scrutiny. The first is that such a policy would be necessary to further a compelling interest in remedying the effects of societal discrimination. The second is that it might be the only way to achieve the educational benefits of classroom diversity. Both of these arguments are inconsistent with the requirements of strict scrutiny.
The argument that remedying the effects of societal discrimination could be a compelling justification for a racial classification in admissions was rightly rejected in Bakke because it does not address identified instances of discrimination, but rather uses a, quote, amorphous a concept of injury that may be ageless in its reach into the past. In other words, racial classifications are too broad to adjust for historical discrimination.
Counsel, if I could jump in for a moment. You're talking about modern precedents, we'll get to in a few moments. Let's talk about history for a bit. And maybe your team can discuss the legislation passed in the 1860s in the Reconstruction Congress and talk about how that legislation may bear on this case.
Yeah, so with regard to that legislation, especially federal legislation, we believe that it is not necessarily important to our interpretation of the 14th Amendment because the 14th Amendment, firstly, was not understood to apply to the federal government at the time. Moreover, we don't believe that many of the laws passed by the federal government in this Reconstruction era were actually making distinct racial classifications, but were rather addressing identified discrimination. For example, the Freedmen's Bureau did not give preference to simply Blacks at large, but rather it gave preferences to former slaves. And I think this is relevant to the doctrine of identified discrimination versus broad social discrimination, racial discrimination, as established in the city of Richmond case.
A question to Connor, your partner. Some of the laws were based on being a former slave, but some of the laws actually specifically said people of color. They referenced people's race. How should we look at that as evidence of what the framers of the 14th Amendment might have thought about what was required?
Well, I believe that we should view this as the framers' attempt of the 14th Amendment attempting to address this identified discrimination that was occurring at the time that heavily coincided with the race of these people.
Well, but wouldn't that suggest that race-conscious measures would be permissible?
So these race-conscious measures are impermissible unless they are impermissible. The only situations where these would be accepted would be situations where these are targeting groups which could coincide with racial groups that have been the specific target
But,
of.
but based on history, wouldn't these statutes suggest that the framers of the 14th Amendment were okay with race-conscious measures? Isn't that the history we can draw?
So I would like to reiterate one point and then add a second. My first point would be that these statutes were largely enacted by the federal governments, the one
So
that you are referring to.
Okay, so I'll take your point about the federal government. Well, let's just assume that, you know, there's federal military academies, right? Can they use affirmative action? Let's just stick with that if it makes you more comfortable. Wouldn't this history be evidence that the framers thought that the Equal Protection Clause did not bar race-conscious measures?
Well, first, I think that we should look at some of the things that were said in the founding discussions. For example, Thaddeus Stevens, an instrumental founder of the 14th Amendment, stated that one of the goals of the 14th Amendment, indeed the largest goal, was so that the law which operates upon one man shall operate equally upon all. And referring specifically to those racial classifications that may have been made, I think that we should go back to, I know that scrutiny levels weren't around at the time, but it kind of ties into our modern conception of strict scrutiny. I think that shortly after the Civil War, it can be seen that there was a much bigger compelling state interest in addressing discrimination than we may have today, over 150 years after the Civil War.
To add on to this, when we're talking about legislation that has been passed in the 1860s leading up to mid 20th century, it's also important to acknowledge that during this time, a lot of the race conscious policies that were passed that used broad racial qualifications were things that would be deemed unconstitutional later by the court. For example, the segregation was passed during this time, and which also used these racial classifications. And this,
Let me, Council, if I
Yeah.
can jump in for a minute and ask a question, please. Let's say you prevail, and let's say universities wind up with a freshman class that's 100% white, and they do everything they can, and they're not able to attract any minority applicants. Would that be okay?
No, I don't think that would be okay, because if this were the only alternative, then it would be clear that universities would have a compelling state interest in enacting a race conscious policy.
But then doesn't it undermine your position? If you're saying there's room to use race, why do we overrule Grutter? Shouldn't we be reaffirming Grutter?
No, because for example, in the case of Brown, it was important to consider the historical circumstances of the time, and just in this case, it is also important to consider our modern circumstances. And I think that the evidence shows that universities, including UNC, have race-neutral alternatives that do not compel them to use race. For example, UNC rejected one alternative that would have resulted in a very similar racial composition, undeniably superior socioeconomic diversity. And the reason for that rejection was that there would have been, I believe it was a 56-point drop in the average SAT score in the freshman class. And I think that shows that there is no compelling state interest in the case of UNC or in general with universities in enacting race-conscious policies. Other universities that are no longer considering race have been successful in establishing a broad type of diversity that transcends racial diversity without sacrificing racial diversity. For example, the University of California system went from 19% Black and Hispanic before Proposition 209.
There's a question for your partner. I'll make sure we balance it a little bit evenly. But California has come to this court and said that they aren't able to keep a diverse class with Prop 209. And now this sort of requirement spread nationwide. How do you respond to that argument?
Well, so after Prop 209, the UC system has been able to achieve similar levels of.
But they say it's not enough. But California comes here and says that they're struggling, that they're not able to achieve the diversity they need to. How do you respond to that?
So just to get into some of the statistics before I address the question, first, the UC system's enrollment of Black and Hispanics in 1999 was 19.3%, whereas it rose to 43% in 2021, where 1995 was the last year before Prop 209. And when this level should be deemed sufficient to gain the educational benefits of diversity. And to claim that this level is insufficient would suggest that they are.
Agree that this interest is compelling. Counselor, do you agree that this interest is compelling?
We agree that there is a compelling interest in achieving diversity. However, specifically in regard to racial diversity, it is not necessarily going to be a compelling state interest, because the diversity and the benefit that they gain from that is from the diversity of backgrounds, and to use race as a proxy for different experiences and backgrounds is not always going to be accurate.
I think that the statement of amici in the UC system, which in our view misrepresents their situation with attaining diversity, speaks to why the Grutter standard or the Grutter decision, which afforded deference to a university, was wrongly decided. We believe that deference is unfair in this case because we can objectively assess whether a university is able to attain diversity by race-conscious measures.
All right, I see that your time's up. Thank you very much. Respondents, please come on camera. You'll have 15 minutes. Begin whenever you're ready.
Wait, is the timer up? Okay. May it please the court. My name is Caroline Reedy. My name is Kaylee Ricker. And we represent the respondent in today's case, the University of North Carolina. The issue at hand is whether or not race-conscious affirmative action is consistent with the 14th Amendment to the United States Constitution. We argue that it is.
We would first like to point out that within our opposing counsel's brief, they contend that stare decisis and reliance interests are not necessary in regards to today's case. While it may be true that the court has strayed from pursuing reliance interests and stare decisis, the petitioner's argument aims to completely disregard the framework of our government and to make the Supreme Court legislative. So stare decisis promotes the even-hand, predictable, and consistent development of legal principles and the perceived integrity of judicial processes. Similarly, when regulations change erratically without consideration of reliance interests, regulatory regimes end without ever incurring the benefits that they were enacted or repealed to produce. The system that petitioner suggests disregards precedent cases and essentially suggests to the Supreme Court to make decisions on a whim, which will prove to be unworkable and detrimental to our country.
The 14th Amendment was formed with a specific race in mind. The leaders of the Reconstruction had the initial intent to protect all people, especially Black Americans, from lack of opportunities and unequal treatment due to their race. This shows the historical intention of the 14th Amendment was to protect Black Americans. This directly affects our modern society, showing the initial intent was to protect Black Americans and put them into a society that values equity and representation.
So, Counselor, let me just ask you, let's say we agree with you that there's a strong evidence that this amendment was designed to protect Black Americans. How does it affect other underrepresented groups that are seeking racial preferences that are not Black?
Well, Your Honor, it helps them additionally. Hispanic groups and Black American, Native American groups, they're all helped by affirmative action. It allows
I know they're all helped, but if we're making a historical argument, were any of these groups on the forefront of the minds of those who drafted the 14th Amendment? Were they thinking about these other groups?
Well, I guess they were, because the wording of the 14th Amendment says that it protects all Americans, not specifically Black Americans. However, we argue that the intent of the 14th Amendment was based on Black Americans, but the writing of it was to include all these minority groups.
What do we do with that? What if the text says equal across the board, but then you're telling me the intentions go towards a particular racial group? How do we reconcile that? I'm not following your argument.
Will you re-ask your question, sir?
Well, I think I just heard your argument. You're saying the text of the 14th Amendment is equal across the board for everyone. You're saying some of the intentions are focusing on one particular group, Black Americans. How do we reconcile that where the text maybe goes one way, but the intentions go a different way?
Well, Your Honor, the intentions are to help equal the playing field, while the text does the same thing. They both have the same goal. However, the initial intent of the 14th Amendment was to make it so that there was remedial action against the discrimination against African Americans at the time, but also allow all minority groups to get the same equal opportunities.
So while the 14th Amendment was mainly to help freed slaves and other Black Americans, we can see that they were discriminated against at that time, and we can apply that to today's case where these.
I thought that the purpose of the 14th Amendment was to ensure that there was equal protection for all people. And so what precedent shows that it was particularly created to help Black Americans?
Yes, they wanted equal protection. However, Black Americans were not given equal protection before this time, and so they needed something to help them get to that equal standard that white Americans were already receiving.
And at what point are they to that equal standard? Because Justice Day O'Connor stated in Grutter that after 25 years, affirmative action would no longer be needed. So is there a point in which the affirmative action is no longer going to be needed because they've reached that standard?
So affirmative action cannot be justified by a specific number, as we have seen with the as quota systems have already been seen as unconstitutional, and it must be seen as a case by case basis. Affirmative action, it is easier to see when diversity and equal representation. It is easier to see when equal representation and diversity is not reached than it is when it is reached. And so all that we need to see right now is that it is not being reached, and therefore.
So, Counselor, since affirmative action has been present for 22 years now, and that goal is not being reached, do you think affirmative action is doing what it's supposed to do?
Well, Your Honor, yes, I believe it is doing what it's supposed to do. It is serving as a remedial action to help the the unequal opportunities that these minority groups have. In today's society, there is still racism, and there's systemic racism among classrooms growing up. Some kids might not be offered the same education that others might.
Let's talk about Asian Americans for a few moments. Where do they fit into your discussion of, racial preferences?
Well, Your Honor, in our case, Asian Americans are overrepresented in universities. So when, in our case, we are seeking to help.
So you want to make them less represented? So you want fewer Asians to be admitted?
No, I would like to clarify what my co-counsel said. Asian Americans are pleasantly represented in universities.
You said pleasantly?
Okay, maybe not pleasantly.
I don't know what word. I just maybe use a different word. I'm not sure what you just said.
Accurately? Somewhat.
I don't know what you're saying. Just spell it out. Just say it. I'm not sure what you're getting at.
While Asian Americans are still discriminated against in society, they are meeting a certain not standard, but they are
in the admissions process in universities. They are not it is not shown that they have unequal opportunities growing up, whereas these other minority groups do. They are not offered the same educational benefits as Asian and white groups are.
Are you seeing people of Asian descent are facing difficulties growing up? I'm really not sure what you're saying.
No, sir. Asian Americans are definitely still receiving discrimination. However, due to statistics in general, we can see that Asians are not underrepresented in universities, and therefore they do not apply to the affirmative action that is seeking to help Black and Hispanic Americans that are not being represented in universities.
I think Justice Gus has a question. I apologize for cutting you off.
Counselor, when I hear the word overrepresented, it seems to be like the only natural remedy for it would be to admit less Asians. So is it your argument here today that less Asian students need to be admitted in order to help more Black and Hispanic students be admitted?
No, sir, we are simply looking at the margin. In order to decide whether affirmative action is okay. So we're looking at the margin. The highest achieving white and Asian students are already admitted and not competing. And those disadvantaged by affirmative actions are already on the margin of not getting in. So therefore, the lowest achieving of those students will not attend, and the highest scoring of Black and Hispanic students will attend. We are simply looking at the margin. Affirmative action acts not as a master policy, but a policy.
But aren't all other races besides Blacks and Hispanics, according to you, disadvantaged by affirmative action? So you're stating that the Asian Americans or Asians are unable, they are disadvantaged from affirmative action. Isn't that correct?
Well, Your Honor,
Was someone asking a question or? Okay.
No,
well,
I
Your Honor,
think-
okay. Asian Americans are not specifically disadvantaged by affirmative action. It is just affirmative action is meant specifically to help aid the diversity on the campus, as we has mentioned. And in this instance, we're saying that the higher achieving Black American and Hispanics students should be able to get admitted to the university, whereas the lower achieving Asian American and white Americans should not.
Counselor, let's maybe change gears a bit. Can you talk a little about stare decisis and maybe Dobbs and discuss, what are the standards needed to overrule Grutter as your friends on the other side request?
So with stare decisis, we can see that if something has had a historical significance in the past and has rooted our country in it, then it should not be overruled. And we can see that this is why Roe v. Wade was overturned because it was not as historical as, say, race and affirmative action is in this case, and cannot be applied to the same standard.
Well, what if we find that Grutter and Bakke were egregiously wrong? Wouldn't that mean we have to overrule those precedents?
In today's case, we are trying to show that these cases are not wrong, that they do indeed set a workable standard for affirmative action, allowing diversity in these campuses.
Okay, may proceed.
All right. UNC has a compelling interest in facilitating a diverse student body. The 14th Amendment's authors themselves pursued race-conscious policies that were necessary to ensure that the gulf which separates servitude from freedom is bridged over. Acknowledging race as a factor in a student's unique perspective introduces students' cultural and racial differences that can have positive impacts on a learning environment. UNC's mission is...
But the petitioner brought up an interesting point about the difference between racial diversity being a compelling interest versus student body diversity. Can you clarify your position on which y'all believe is the proper compelling interest?
I believe that they can both tie into each other. Racial diversity, we can see that there is still discrimination, and those that are being discriminated against will have a unique perspective against those who are not discriminated against as much. And so those unique perspectives, when they join forces, if there's a better word to say it, will share their collective or share their opinions, and I think can overall benefit a learning environment and student body as a whole.
Yes, Your Honor, there's a large amount of diversity among UNC's campus. Racial diversity is one we strive to achieve through affirmative action, but also there's a large international student population showing diversity further in the campus to allow a higher education to be beneficial for all students.
But are international students given the benefit of affirmative action?
I believe they are held to a different standard since they are of different countries, but I am not completely sure, to be honest, Your Honor.
Counselor, let's maybe talk a little bit. So can you talk about Justice Harlan's dissent in Plessy v. Ferguson, please?
Yes, Your Honor. In his dissent, he discusses how the Constitution is colorblind. However, we find that it is not, that the intention of much of it was to help aid minority groups and to recognize all of the different ethnicities to create a balance.
Do you think Harlan was wrong?
Sorry?
I think Harlan was wrong.
It is not that Harlan was wrong. It is that it was a theory. It was the dissent. It was not the it was
mean,
not the
I hate to say it, do you agree with the majority opinion in that case?
no, definitely not, sir. I don't agree with the majority opinion.
So
Yeah.
our constitution can separate people based on their skin color.
No, Your Honor, we're not saying that you can discriminate. However, you are saying that affirmative action in our case is a remedial action, allowing for equal opportunities to help with this. Additionally, when Plessy got overturned, the idea of colorblindness did not make it into the arguments. It was completely disregarded and got rid of as a theory.
Okay, you have 30 seconds left. You can wrap up.
The University of North Carolina pursues the interest of diversity in compliance with this court's precedents, which have consistently held for decades that seeking the educational benefits of diversity is a compelling interest of the highest order, and that universities may consider all aspects of an applicant's background to build a thriving campus community. It is for these reasons we pray that the court rule in favor of the respondent. If there are no further questions, we pass to rebuttal.
Okay, thank you so much. All right, if the petitioners come back on, you have 5 minutes for rebuttal time. Whenever you're ready, you may begin.
Okay, so we would like to first address the point that our opponents have made about stare decisis and reliance interest.
Sorry, your camera's off, I'm sorry.
Oh, I'm
Okay, I'll reset your timer. Go ahead. Go ahead.
Am I on? Okay.
Good.
My apologies for the interruption. So we'd like to begin by addressing our opponent's arguments about our position on stare decisis and reliance interest. They suggest that we would completely disregard reliance interest and stare decisis, effectively rendering the court legislative. However, as Alito stated in his opinion in Dobbs v. Jackson, stare decisis is weakest when we interpret the Constitution. For example, Plessy should have been overturned on the day that it was decided, and we would not argue that Brown was wrongly decided because it overturned Plessy, especially in light of the immense social impact, the salutary social impact that decision had. And we consider that this case is of similar social importance.
So I take it you think that Justice Harlan's dissent in Plessy was correct, right?
Absolutely.
I think this question for Connor. So then what role can government use to classify people based on race? Is there any role, or is it completely colorblind?
So as was established in the City of Richmond case, when there is an identified discrimination that is present, they can.
Okay, no, I get that. So you're saying only where you're remedying actual discrimination, right? You can't just use. Do you think there's no basis to use racial preferences to achieve diversity in education? Is that your position?
Yes.
All right, let me ask you a follow-up. Let's say we don't overrule Grutter. Let's say we leave Grutter in place. Can you still win?
Yes.
Okay, tell me how.
I'm sorry, Connor, please continue.
So if Grutter is still in place, we can still win in that Grutter allows for these universities to achieve diversity through metrics other than race. And we should focus on these other metrics as being the basis for these admissions policies rather than race.
So to just add on to what my partner was saying, he was explaining that Grutter believes that once a university has sufficiently considered alternatives, it would be able to enact a race-conscious policy. So if that precedent is unfortunately upheld in our view, we could still rule that UNC has not adequately considered alternatives, which we do believe, but we could not fully ban race-conscious affirmative action policies, and we believe that that is truly what is most consistent with the 14th Amendment. So if I may be permitted, I'd like to get into some of the statements.
Hold on one moment. So if they adequately use these other policies and they don't reach the compelling goal of making the school diverse, then affirmative action is constitutional?
Under the precedent of Grutter, yes, it would be, but we believe that Grutter should be overruled. So I would like to get into some of the points that our opponents have made about Asians. They effectively imply that since Asians are overrepresented in UNC, they cannot be given unequal opportunity within society. This clearly seems to be the view that UNC takes in its admissions process, which defines an underrepresented minority as a group with a smaller population within UNC than within the state at large. However, we don't believe that this is a good way to measure whether a group is actually facing discrimination or deserves a preference or a harm. We don't believe that this is the justification for the discrimination against Asians that UNC exercises. As amici representing the Asian community bring up, there's a terrible effect on the dignity and self-worth of students who know they will face discrimination if they are seen as Asian. The Princeton Review actually advises.
But Counselor, I mean, I think I asked this question before. What happens if we overrule Grutter and Gratz, and despite their best efforts, universities cannot recruit minority applicants, a class of 1 or 2 Black students? Wouldn't that affect the self-worth and dignity of the African-American population?
Well, as we have stated, there's very little, we disagree respectfully that this is a circumstance that will happen. We believe that as was shown with the UC system, they were able to achieve, and with Florida's university system, they were able to achieve similar levels of diversity without taking these this race into account in these admissions processes. However, if these policies are proved to be completely necessary to achieve diversity, which we contest, then there may be basis for the compelling state interest.
Yes, so there might be a compelling state interest in some case, but it is our position that in the modern America, there can be no compelling state interest in using a race-conscious policy.
Okay, thank you so much. Time's up. All right, well done. If the other team can please get back in camera. Congratulations to both teams. I know how hard this was. I know how difficult this was. And I'm sure you will go back and watch these recordings later, like, oh, I should have said this and I should have said that. That's part of the game. But you are now in the world of what law students do. You practice, you prepare, you get ready, and then you walk into this, you walk into the arena, so to speak. You walk into it. And myself, my former students, Abby and Daniel, grilled you with very difficult questions. And I think in some cases you realize maybe you didn't have quite the right answer, and then you quickly pivoted to try and recover, which is very strong. There were cases where you didn't know the right answer and you were able to play it off. And also, I think you both teams had very good deliveries. You were calm, you didn't panic, you sort of said, no, that's not what I meant. You sort of correct yourself, which is very good. But I saw a lot of really good talent here. And I think you guys were well on your way. If you want to go to law school and do other things, you'll do great things. So thank you so much. And maybe if Daniel or Abby have anything they want to add, I welcome them to do so.
Yeah, I just want to say that everybody did so great, and your arguments were strong, and both teams answered questions very well. You were very responsive, and I don't know if it's Kaylee or Caroline, but one of you, I asked a question and you didn't know the answer, and just saying, hey, we don't know the answer. I think it's hard to do because you think you're supposed to know the answer, and you are, but I think it's really great to just be able to say, hey, I don't know the answer, and move on. So that was impressive.
Daniel?
Yeah, great job, guys. It really it impresses me every time I do one of these rounds. Like Abby said, great job on being responsive. I really liked on the petitioner side that you addressed the respondent's argument directly on rebuttal. I think that's a very strong way to end with positive thoughts from the judges. And on the respondent side, I really liked how y'all crafted your argument in relation to our questions. I think we were really kind of drilling you there at one point with questions, and y'all kept your composure, and it was very well done. Good job, guys.
I can just give also some feedback. I know it's tricky that Aubrey and Connor aren't in the same location, which it makes it trickier. But you should still try to work to balance workload roughly in half. At least even the opening statement was not in half. So try to keep the workload balanced. It often happens that one partner tries to talk more than the others, and something you can work on as well. In terms of eye contact, I think sometimes you're both looking at papers or looking down. Try to keep eyes on the screen. Especially on Zoom, it really does make a big difference. When you're in person, it's not as important, but when you're remotely, if you're not looking at the camera, it looks like you're looking away from us. With Kaylee and Caroline, I think your rapport actually worked well because a couple of times each of you misspoke and the other one tried to jump in. No, that's not what she meant, right? So I think you have to sort of work on how to do that massage. You don't want to look like you're throwing your teammate under the bus, right? You want it to look more like more like casual, like not correcting your partner, but say, Your Honor, another way of thinking about this is, or Your Honor, maybe there's some other way we can answer this question. That way it doesn't look like there's so much of a, like you're bailing them out, right? Which is, I think, what happened. That one line, I think it was Caroline said that Asians overrepresented. I'm like, oh man. I know the second you said that you regretted it, but yeah, you can't say there's too many Asians on campus. That's going to burn you really bad. Oh goodness. And then I think Kaylee was saying, oh, they're pleasant. I didn't know what you were trying to get at with that. I think you were trying to avoid saying too many of them or something. I wasn't quite sure.
I was trying to say that like they aren't underrepresented, but I didn't know how to say like adequately represented. So I said pleasant.
No, that's what I figured you were getting at.
I think I kept thinking you were trying to say proportionately, like to the population.
Sure.
Yeah, proportionately.
That's good. Yeah, I mean, there'll be times when a judge will sort of hit you with the question and then you start having to flail and panic and get out of it. So one thing you have to practice on, and Daniel and Abby practices in their moot court classes, is how to pivot to a strength. And you can say, well, you know what, this is going really bad for me. Let me get the hell out of here. Let me try and change the subject. And maybe the judge will let you, maybe they won't. But try to get back to where you are. For example, talking more about just Harlan and Plessy or Brown or something historical. But I think both teams definitely had their remarks prepared. They did well, and I'm very excited to see what you all do when you get to college. And now, are you juniors, sophomores, seniors? What year are you all?
Juniors for us.
Yeah,
We're sophomores.
Okay, so you got a ways to go. Yeah. I've been working with both of your coaches for many years now, and you've had a lot of students come through and even going to college and law school. So I'm happy to see you all thrive. Any questions you want to ask of us?
I did want to ask, the next round is a round of 8. Is that 8 teams on petitioner, 8 teams on respondent, or is that 4 teams on each side?
I should remember, and I don't. I'm blanking.
I believe it's 4 and 4.
I think it's 4 and 4. Yeah, if my memory serves. Yeah.
All right, thank you.
No, I had a momentary brain lapse from it. Yeah, it's 4 and 4, and then it's 2 and 2, and then the top 2 teams fly to Washington for the championship in April, which is always very exciting. Or
Thank
fly
you.
to train, or however they get there. Okay. All right. Any other questions from the other team, from the coaches? All right. Well, if I could please ask the students to sign off, we will do the grading. But thank you so much, and I wish all of you the best of luck. And if you're ever in Houston, you're welcome to come visit my class, and you're welcome to email me with any questions or anything on your mind. Thank you.
Thank you.
Thank you.
Thank you so much. See you later.
Josh, do I click off and then back in? How do I do that?
Yeah. If you could just leave the room and come back in, I'll read it in a few moments.
Okay. All right. Thank you.
Thank you. I'll stop recording.